Welcome, everyone. We are so excited. It's Super Bowl Sunday. If you don't know, it's the Kansas City Chiefs versus the Philadelphia Eagles. We had a little bit of a discussion about whether people were offended by the name of the Chiefs, but what was more important is we discussed how great the Eagles were, and that over 60% of the class thinks they're going to win. So I'm still rocking my Super Bowl championship shirt from the last time we won, and that's what I would tell the Eagles players. I'd say some of you in this locker room have been here before and you've won. Let's take care of business. You know what it tastes like? Let's go have a bite. Some of you in this room have passed the MBE before, different jurisdictions before. You've passed the Series 7 to Mara. You've passed the LSAT before. You know what victory tastes like. This is nothing new. A lot of people in the Eagles locker room were there 2 years ago when they played the Chiefs and they lost. Very comparable to a lot of people in this room who took this test before and did not pass. So there's two ways you can go about that when you're revisiting something or someone that's conquered you before. You could go back with a lot of doubt, a lot of anxiety, or you could really take it and be like, you know what? I could definitely beat that person or that test. I just didn't have the best approach the last time. How could I change my approach this time to get the result that I'm looking for? So I recommend the second approach, and it's not reinventing the wheel here. Over prepare, over perform. Execute on test day. Same thing. The Eagles, they've been preparing all season. Now go out there, take care of business. They got this running back who's like jumping over people backwards. They got this play where they can score any single time. Just do the things you're confident and it should work well. Same thing with y'all in the MBE. Just you've taken all these questions before. The questions that you're going to see on test day are going to be so similar to the ones that you've seen. So just get them right. Sure, there's going to be some low hanging, sure, there's going to be some crazy questions that you have never seen before and you're going to get it wrong. Yeah, Pat Mahomes is probably going to throw a touchdown to Travis Kelce and Taylor Swift's going to do a dance. Like that's probably going to happen, but the game is not decided by a singular question or singular play, right? After Travis scores and then Taylor descends from the sky singing like that gets proposed to, like after all that crazy stuff happens, Eagles get back to the huddle and score another touchdown. And then the game continues on. If you get a question wrong, just go right back to the next question. Just stay confident, stay calm, be mechanical. And really, I'm confident in every single person in this room that they can pass the MBE. If you're not confident today that you can pass the MBE, but you realize there's 2 weeks until the day of the MBE, what should you do? Every single NCBE question that's ever been disclosed over and over and over and over and over again until you can get them all right, and then you'll pass. No reinventing the wheel here. Make sacrifices. The things that are going on in your life are not that important compared to this. And it's human nature to preemptively give yourself an excuse for failing. It's human nature to get distracted at the last minute. It's human nature to talk negatively to yourself. These are all humans' nature things. Humans are going to be humans. And Vic asked me last class, if I consider myself a human. Straight down to the core of my DNA, right? I've been there before. I get anxious. I don't have good sleeping patterns. I get sick right before the test. I start doubting myself. I think of every worst case scenario. Yes, this has happened to me before. But looking back, I've been like, when have I performed at my best? When I walked in there and gave myself that talk, like, come on, Andrew, you could do this. This is easy money. Like these people in the room, they haven't been through what you've been through. They don't know how hard you want this. They didn't study how hard you did. And you know what? So what? It doesn't matter. It's just a test. I'm going to take it again if I have to. But like this time, I'm going to give it 100%. Every single question, locked in, laser focus, recognizing it could come down to the wire. So every single play matters, right? That third, first quarter, if a player has a drop, that's important. That could be the reason, the extra point that the kicker missed, right? Every single play matters. Do your best on every play, but at the same time, the game moves forward, the test moves forward. So just calm, confident, mechanical, never too high, never too low. It's not an easy test. Every question deserves discipline and focus and consideration, but it's not a hard test either. It's a low-hanging fruit test. Just get all the easy questions right. All right, so that was my game day speech. I got Eagles 38-23. I think it's going to be a nice, smooth victory. Vic, do you mind sharing your screen so we can do the first question? Oh, I got to give you the share screen capabilities. Okay, and I'm going to pull up the first poll, and let's just run through some questions today. We got 62% picking the Eagles. He went against Vegas, but he went with me, which I appreciate. All right, so I got the first poll up. Can y'all see Vicky's screen? I can. Okay. I can.
Good. Do you see both?
I can see clearly now that the rain has gone. I can see all obstacles in my way.
Good.
Did anyone watch the fight last night? I fell asleep, but I saw the news. Dude got punched a lot in his face. Okay. May State A federal court hear the action? A tenant living in State A sued a landlord from State B in a single count complaint filed in the Federal District Court of State A. The complaint alleged that while the tenant was living in an apartment building owned by the landlord in State B, the landlord breached his duty to keep the premises secure and a break-in occurred, causing the tenant $90,000 property damages. 10 years before the tenant filed the lawsuit, the landlord inherited a small farm in State A from his father. The landlord has never visited the farm or been physically present in State A. The landlord's farm is valued at $50,000. May State A federal court hear the action? Yes, because the parties are diverse and the landlord owns property in State A. Yes, because the parties are diverse and the value of the landlord's property exceeds $75,000. No, because the value of the farm is less than the tenant's alleged damages. And no, because the property has no relationship to the lawsuit and the landlord has no other contacts with State A. So the question is asking about personal jurisdiction, right? No, I'm sorry. The question is asking about subject matter jurisdiction. Subject matter jurisdiction. And they're seeing, can the federal court hear the case? Does anyone remember when a federal court can hear a case?
Federal question or diversity?
Diversity or federal question?
All right, yeah, let's put Heather up right now. Well, I'm going to have some students talk with me. So Heather, federal question or diversity? What are they looking for here? Federal question or diversity?
They're looking for diversity because this is
Right.
not a federal question. It's related to property.
Nothing to indicate a federal question, and they're throwing some numbers at us. The numbers are important because we need $75,000 for diversity. Okay, so in order to have diversity, the case in controversy has to be over $75,000. And what's the other key component?
That the parties must be diverse. The plaintiff and the defendant cannot be from the same state or from the same.
So the amount in controversy is $90,000. That seems to be fine. Now, are the parties from different states? Well, the tenant is from State A and the landlord is from State B. But 2 years before the tenant filed the lawsuit, the landlord inherited a small farm in State A and his father. The landlord never visited the farm or has been physically present in State A. So does that destroy diversity? Is the landlord also from State A because he owns a farm there and has never visited?
That is not enough to subject someone to personal jurisdiction.
And therefore, since we have the amount of controversy and we have diverse parties, should the federal court be able to hear the claim?
Yes.
Yeah, so let's eliminate, wait. May the State A federal court hear the action? Yes, because the parties are diverse and the landlord owns property in State A. Yes, because the parties are diverse and the value of the landlord's property exceeds $75,000. No, because the value of the farm is less than the alleged damages. And no, because the property has no relationship to the lawsuit and the landlord has no other contacts with State A.
Isn't this a personal jurisdiction question?
I was thinking personal jurisdiction. No, I agree that I did that initial analysis that we just did, but then I was thinking that they're talking about the property to subject him to State A because he lives in State B. So I think it's that the property has no, my initial thought is D, it doesn't have any relationship to the lawsuit. And doesn't have any other contacts with State A.
Exactly. So yeah, again, that's part of the test, right? I went down the whole wrong path. I was like, it looks like they have subject matter jurisdiction. But then I looked at the answers. I was like, oh, but they're asking about personal jurisdiction. So D, the property has no relation to the lawsuit and the landlord has no other contacts with State A. So who's filing the suit here? The tenant is suing the landlord and
in State A.
in State
federal
A.
court in State A, but the landlord is from State B.
And there's no cause of action that occurred in State A. So the State A court will not be able to exercise personal jurisdiction over the landlord. So the answer will be D. Nice. All right, sweet. Class seemed to be in agreement, right? Although the court has subject matter jurisdiction, right? So like it wasn't a problem to go down that path, right? Because they needed to have that. But then I was like, oh, wait, there's another path to go down. It does not have personal jurisdiction over the landlord. Owning land that's entirely unrelated to the subject of the underlying suit with no other contacts in state A prevents the court from constitutionally exercising PJ over the landlord. So simple takeaway from this one is, in order for a court to exercise PJ over a party, they must have minimum contacts. Merely owning a property in a state, but having never visited, will not satisfy this requirement. Good work, right? Good work, class. Good work, Heather. And way to go through that. I mean, I almost led you astray, but then you're like, wait, this isn't even an SMJ question. This is actually a PJ question. Maybe it could have been a venue question, but it wasn't. Vic, I don't know if we could see your screen.
You're muted, Vic.
Let me stop and do it again because I like lost it.
Sorry.
Share.
Yeah, Eric's saying, wouldn't venue be improper for that situation as well? Yeah, because where's venue proper? Eric, let's bring you to the mic. Where is venue proper?
It would have been where the controversy occurred. So the property was in state B. So it would have been proper to bring the action in state B.
It's where the cause of action occurred, or
Right.
When I say the property, I mean the property that the tenant was leasing from the landlord.
yeah, no, I get that. So venue is proper where the cause of action accrued, or where else?
Where a defendant.
Where the parties reside.
Right, where
Defendant
any of the
reside.
defendants reside
Got
if
it.
the parties live in the same state. And then the third provision, if neither one of them can be satisfied, would be any court where they can exercise personal jurisdiction over any of the defendants. But the first two
Okay.
properties are where the cause of action accrued or where any of the defendants reside if they're all living in the same state. And then if neither of those
Okay.
properties can be satisfied, we'll go to the third one, would be where they can exercise personal jurisdiction over the party. But you're right, they couldn't exercise personal jurisdiction. Defendant doesn't reside there. The cause of action didn't accrue there. So PJ and venue would be inappropriate. Good.
So hypothetically, and I don't mean to be like, Gunner right now, throwing out like a hypothetical, but you and I are both residents of the state of Florida. If I own a property in Georgia and I lease it to you, and you sue me for like, a breach of, the warranty of habitability, you can bring that action against me in Florida because Florida has personal jurisdiction over us, even though the controversy arises over a lease in Georgia.
Yeah, well, anywhere I can bring it in the venue where any of the defendants reside. So that'd be your venue in Florida or where the cause of action accrued. So, if the property that was, the habitability probably happened in Georgia, that venue would be appropriate too. So there's two appropriate venues, meaning
Yeah,
that
but you could bring it in Florida. That's what I'm saying. Like venue, Florida would be a proper venue.
Yeah, there's two proper venues, and that's why potentially we can ask a question about transferring between those two venues. And the answer would be yes, because a venue could be originally proper, you can transfer. All right, let's try this next one, Vic. How should the court rule? So a woman inherited a house from a distant relative. The woman had never visited the house, which was located in another state, and did not own it. Upon learning this, the man who lived next door to the house called the woman and asked to buy the house. The woman agreed, provided that the house was sold as is. The man agreed, and the woman conveyed the house to the man by warranty deed. The man had purchased the house for investment purposes, intending to rent it out while continuing to live next door. After the sale, the man started to renovate the house and discovered serious termite damage. The man sued the woman for breach of contract. There are no applicable statutes. How should the court rule? For the woman, because the man had planned to change the use of the house for investment purposes. For the woman, because she sold the house as is. For the man, because the doctrine of caveat emptor, or for the man, because he received a warranty deed. All right. Anyone feel good about this one? I mean, a lot of the answers, 94% of y'all picking the right answer. Who feels good about it?
I feel good about this. I did
right,
this
Gabby.
question yesterday on UWorld.
What's the answer and why is it the answer?
I think it's B, because usually when you sell the property as is, it kind of negates the purpose of the warranty deed, like that you're making promises, because a general warranty deed is usually 6 promises. But when you're selling it as is, that's like basically waiving like any potential issues that you can find after. So it's like the excuse.
100%. And I love what Vic highlighted. The woman sued the man for breach of contract, right? Well,
Yes.
if you're suing for breach of contract, it's a little late for that, right? We have already have a warranty deed. So that's merged into the deed. If anything, the only thing I could see them suing here for under the deed would maybe be a breach of quiet enjoyment. But even so, I don't think so, because it's supposed to be a claim on the title, right? A quiet enjoyment would be claimed to title. This is just you have termites. I think your best claim here would have to be like um I don't know. You're pretty. It's gonna be hard for you to receive because you bought it as is. You should have known about the risk. So I agree with B, basketball. I don't think you have any claim here. A seller may disclaim any duty to disclose defects. The disclaimer is sufficiently clear and specific. In this case, the contract specifically noted as being sold as is. The woman made no misrepresentations regarding the conditions of the house. There are no statutes that might require an owner-occupier to disclose known defects. In any case, the woman inherited the house and never visited or lived in it. In addition, it is not the sale of a new house by a builder seller, which may impose a warranty of habitability. Let's pause on that for a second. Did everyone know that in new construction, there is a warranty of habitability?
Yes.
That's important, especially if you take the UB and have to write essays.
Yeah.
There's a warranty of habitability in new construction homes. All right, nice. So
And it
let's-
applies to subsequent purchasers.
So
And I would love to add one little detail in that. If the builder builds the house, there is another extended warranty for that. If the house was built by a builder,
as opposed to
just the generally newly built house, the
Right.
heightened liability.
right, because they put their hands on it. I agree with that. Okay, what about caveat emptor? The doctrine of caveat emptor states that the buyer accepts the property in its current condition. Therefore, the caveat emptor doctrine would not protect the man as a buyer. In fact, a seller may disclaim any duty to disclose defects if the disclaimer is sufficiently clear and specific. In this case, the contract specifically noted the house is being sold as is, and therefore the woman should prevail. So let's kind of tease this out. An as is clause is a valid disclaimer, right? They said a valid disclaimer to disclose defects, yeah. So if a property is sold with an as is clause and a warranty deed is delivered and there turns out weeks later to be termites, they cannot sue for breach of contract or failure to disclose. There's a little caveat there too, if we're getting into super caveats, not caveat emptor, but caveats. Under Johnson v. Davis, sellers of residential real property have a duty to disclose known defects, right? So if they would know, like you can't like just, even if you put an as is clause, if you know about this defect, you still have a duty to disclose it. That's actually a Florida landmark case, but it's a federal too. All right, can we do another question? All right, a man became angry after he was expectedly laid off. So on these facts, what's the most serious offense he could properly be convicted? All right, murder, voluntary manslaughter, involuntary manslaughter, and assault. Just by looking at the answer choices, you got to understand what are these crimes. Murder, first degree premeditated, cold-blooded malice aforethought, or intent to inflict great bodily harm that leads to a killing, or depraved heart, or felony murder. If it's any of those four, we're rocking with murder. Voluntary manslaughter, adequate provocation, pool boy, you slap, I stab, or imperfect self-defense. Involuntary manslaughter, criminal negligence, texting and driving, drunk driving, someone dies. Assault, it's a crime. Attempted battery in the majority of jurisdictions, or in the minority of jurisdictions, placing someone in a reasonable apprehension of imminent harm. All right, let's see what happened here. So a man became angry after he was unexpectedly laid off from his longtime job as a factory worker. The next day, he returned to the factory floor and indiscriminately fired shotgun's murder into the air, right? The man would later testify without contradiction that he had not intended to kill anyone, but had simply sought to exact revenge on the factory's attorneys by shutting down operations for the day. Unfortunately, one of the bullets ricocheted off the wall and killed the man's best friend. The crimes below are listed in their setting order of seriousness. Is murder, chalk it. Why is it murder? You can't shoot guns into the air. The firing of warning shots will constitute which type of murder?
Braveheart.
Depraved
Depraved
heart.
heart. Depraved heart. Depraved heart. Depraved heart. Depraved heart. You can't just shoot guns in the air. You saw that dude, the Philadelphia Eagles fan? He just shot Uzi into the air or something at the parade. If that bullet came down and hit someone, that dude is probably going to be in jail for damn near the rest of his life, right? All right, A is correct. The most serious offense for which the man could probably be convicted is murder at common law. Murder is defined as the unlawful killing of another human being with malice aforethought. Malice aforethought exists where the defendant acted with one of the following mental states: intent to kill, intent to inflict great bodily injury, reckless indifference to an unjustifiably high risk to human life, acting with a depraved heart, or intent to commit a felony murder. You see how I articulated those four in my mind before I even addressed the question, just to kind of refresh myself. You know what I mean? It's like, it's like a play. Like before you call the play, you're going to look, oh, how's the defense set up? Where are we on the field? What's the score? Orient yourself. The man could probably be convicted of murder, even though he lacked specific intent, because his conduct created such a high risk of death that was so devoid of social utility that it could be found to have acted with a depraved heart, right? And I like doing MBE questions, even if you're taking the UBE essays or Florida essays or California essays, because it gives you good language. I like that language in an essay, right? It's saying it was so devoid of social utility, right? That's a nice little poetic phrase to associate with depraved heart. Devoid of social utility, right? Okay, so firing shots into the air, even with no intention to kill someone, constitutes depraved heart murder because it is devoid of social. What's it devoid of? Social utility. Yeah. It's devoid of social utility and is a act of an individual with a depraved heart. So depraved heart, murder mode. Does anyone know where that's from? Murder mode, depraved heart? You probably wouldn't. That was one of my students, Monique, who passed the bar exam, came to the boot camp, and she participated in the album cover assignment. I actually set murder mode up with one of my employees, well, independent contractors, Allie, because she goes to University of Chicago School of Law and is looking for an internship at the Miami State Department. But I'll always remember Murder Mo with depraved heart, like it's a type of murder. So those album covers do have a little bit of utility, if you catch my drift, right? All right, let's relaunch the poll. Let's do another one. Yeah, Eric, I feel like I'm gonna be good at the dad jokes when I have kids. People have been telling me that for a long time. They're like,
Oh, Andrew,
It comes naturally, man.
what's up, Gabby?
I made a new album cover yesterday.
So I will today, right after class, I'll add that assignment so you can submit your album covers. We're very excited and we'll showcase it this week, Gabby. Appreciate that.
No problem.
I need to make a new one too, and I think I'm going to take your advice and make one with Rosie and Biscuit. Posthumously.
Yes.
Cover. Yeah. I guess not posthumously, posthumously. Okay, let's try this one. How is the court likely to rule on the motion for a new trial? Let's see, new trial. All right, immediately, I'm trying to teach you guys how I do things. You don't have to do things the way I do things, but it's good to see the way someone does things who's pretty good at doing things, right? Like watching Patrick Mahomes. You don't have to, if you want to be a quarterback, you don't have to throw the ball just like him, but you can learn a lot by watching the way he plays. This is how I do things. If I see new trial, I'm immediately saying, okay, what would it allow someone to prevail on a motion for a new trial? Does anyone know?
Mistakes, change of law, jury misconduct.
Newly discovered evidence.
Against the weight of the evidence.
Amazing. That's why I love this class. Like, this is a Super Bowl winning class right here. The three of y'all just nailed it. So, all right, let's see if one of those things happened. All right, an engineer brought a patent infringement action against a company in federal court in state A. The case was tried by a jury. During examination, the engineer's attorney asked one of the company's representatives whether the representative's company was a bottom feeder who swims around buying for next to nothing to house the people who got kicked out. The court warned the Engineers Council against making such inflammatory remarks and instructed the jury to ignore such statements. In his closing argument, the engineer's attorney again made several irrelevant and prejudicial remarks. The company's attorney objected to the remarks and moved for a new trial. This was the first time the attorney objected to irrelevant and prejudicial remarks. How is the court likely to rule on a motion for a new trial? This one's pretty tough. Deny the motion because juries are expected to identify patently biased statements and disregard them. Absolutely not. Please don't pick that answer. Juries are not expected to be able to patently identify biased remarks. That's why we don't let this stuff come in, right? Because juries are just supposed to listen and decide. Deny the motion because the company counsels failed to object prior to closing arguments to the opposing counsel irrelevant and prejudicial remarks. So did they have a duty to object prior to closing arguments? Deny the motion because instructions for the jury to disregard the inflammatory statements as non-evidence cures any harm otherwise done. I don't know. I don't know about that. Just because you told the jury to ignore it, it's like, you know, someone's making a speech and they're butt naked. And you're like, no, just ignore that they're naked. Just like ignore it. It's like, I don't know. I'm kind of looking, you know. Grant the motion because the jury is likely to be biased after hearing the inflammatory remarks and manifest justice would otherwise result. That's another piece of new trial, right? If manifest injustice would result. I think given the taste tests, you know, I go into the ice cream shop, I try 4 flavors. The first 3 were disgusting. I would probably pick flavor D here. Anyone agree with me? Disagree? I mean, the class seems to agree. I don't know if they're just following my lead. You agree, Vic? I think we could get a new trial because it's like, all right, good. D is correct. It's likely that the jury would be biased by the repetitive derogatory comments from the engineer's attorney and manifest injustice would result from letting its future verdict stand. Can you look at the extendo, please? The extended explanation. So what I'm trying to look here is this thing, manifest injustice would result. What did they say there? Do they ever talk about manifest injustice? Not really. If a party witness or counsel conducts herself improperly to the extent there's a substantial risk that an unfair verdict has resulted, the judge may grant a new trial. In rare circumstances, a new trial may be granted for jury misconduct. D is correct. The court should grant the motion for new trial because it's likely that the jury would be biased by repetitive derogatory comments and manifest injustice would result from letting its future verdict stand. So manifest injustice, do we really know, does anyone know where we see that mostly on the test? And this was my boy EJ's, the NFL agent who came in. This was his rap album name. Does anyone know where manifest injustice usually comes in on the test?
Typically on appeal when you didn't preserve an objection, right?
In
Um,
pretrial
Their
conferences.
substantive rights would be violated, which would cause manifest injustice.
Maybe. I'm thinking what the second voice said, which was a amendment of a final pretrial conference order. In order to amend a final pretrial conference order, they would only do it to prevent manifest injustice. For a new trial, I'm usually of the belief that they would order a new trial if it was against the manifest weight of the evidence. Here, they're saying that it would cause manifest injustice because of the derogatory comments, but I'm just trying to see if that's actually from the statutes or not, but whatever. D is correct. The court should grant the motion for a new trial because it's likely that jury would be biased by repetitive derogatory comments from the engineer's attorney and manifest injustice would result from letting the verdict stand. It's a well-established ground for a new trial. All right, well-established. So let's reiterate this well-established rule. A new trial should be granted if a new trial should be granted if the jury would likely be biased by repetitive derogatory comments. The jury would likely be biased by repetitive derogatory comments and manifest injustice would result. So, for example, if an attorney calls the defendant, I was gonna make a Chiefs joke, but I'm gonna lay off them. I feel like I don't even want to dig into what they've already dug into the Native American sensitivity so much. I don't want to dig any deeper. So for example, if an attorney calls the defendant a no good, you would probably know this, Eric. Did you know what the I think it was Blink-182, what their LLC was originally called? You guys can look that one up. A no good meanie face, and the judge tells him to stop, and he does it again on closing. This could be reason for new trial. All right. Okay. So, wait, not this poll. Anyone got every question right so far?
Yes.
Let's go.
Yeah.
Let's go. We like that. Really like that. All right. An action for damages by a driver against the manufacturer based on strict liability, is the driver likely to prevail? Toxic materials. Oh, that's an easy question. Low-hanging fruit question. We got to eat this piece of fruit right here. Toxic materials being transported by truck from a manufacturer's plant to a warehouse, leaked from the truck onto the street a few miles from the plant. This is like the classic example that they teach this concept. A driver lost control of his car, and when he hit the puddle of spilled toxic materials on the street and was injured when his car hit a stop sign. Is he likely to prevail? No. And why not? Because he was not injured by the toxicity of the inherently dangerous material, right? Toxicity, you are strictly liable for. So if, you know, Tommy produces toxic chemicals and Susie walks by and inhales the toxic chemicals and turns into a fish, yeah, that's strict liability. But if Susie is just driving behind Tommy and there's a spill and then Tommy slips on the spill, well, anything could be slippery. If you ever played Mario Kart, you know, bananas can be slippery allegedly. So like on the MBE, bananas are extremely slippery. But like that's the concept here. You have to be injured by the toxicity of it. So basketball, no, the driver's injury did not result from toxicity to materials. I agree with what the class is saying here. All right. So in order to prevail for strict, let's say under strict liability, in order to prevail under strict liability relating to injury caused by toxic chemicals, the injury must be a result of the toxicity in our city, not just the slipperiness of it. Slipperiness of it, for example. Pretty fair. These are all subjects. I mean, this cram guide that we're making from the course right here is amazing. And then when we put it with the master cram guide, that'll be like, I think like 4 administrations of cram guides. I mean, it's like, I can't make this any easier for y'all in terms of just like giving you these points. And you can see like these points I'm making in real time. And I'm trying to like, you know, dumb it down. And honestly, if I wrote it in a way that's like not dumb enough for you, like we said earlier, put it on ChatGPT and be like, all right, Andrew wrote these points. Dear ChatGPT, Andrew wrote these points, but I'm dumber than a rock. Can you please dumb it down to dumber than a rock? And it can do it for you. So like, this is for a rock, right? I made this for a rock to understand, but you have the resources out there to dumb it down even more if you must. Okay, let's do another one. I wasn't trying to make offense. I like rocks. I'm a big fan of rock and roll, actually. Someone would say that I built this city on rock and roll. All right, a pedestrian sued a driver for injuries suffered in a hit and run accident. At trial, the pedestrian called a witness who testified that he saw the accident and that as the car sped off, he accurately dictated the license number into his properly operating pocket dictating machine. What? The witness stated that he has no longer remembers the number. May the tape recording be played? I know the answer to this question. I'm just like, what is a pocket dictating machine? Like, who just walks around with a pocket dictating machine? I guess your phone. So anywho, here's the problem. The pedestrian called a witness to testify he saw the accident sped off. He accurately dictated the license number on his properly operating machine. He no longer remembers the number. This is coming in twice. This is coming in and coming in. It's coming in as a present sense impression. Like you perceived it. Like, look, this is the, you know, license plate number. I'm perceiving it in this moment. It's also coming in as a recorded recollection. Why? Because it actually does meet the requirements of recorded recollection. It was accurate when it was made. They have no memory of it now, right? Yeah, I'm rocking with C, California. See, California, right? Tough question, I guess, but we'll bring it in. The recording is admissible as a present sense impression because it describes an event immediately after it happened. It's also admissible as recorded recollection because it was made by the witness near the time of the event. That was the prong I kind of forgot. The witness's memory cannot be revived, and it's about something the witness once had knowledge of. There's sufficient evidence that the record was accurate when made. All right, so a reading of a license plate number as the car speeds away is likely admissible as a present sense impression. Additionally, if the person who made the statement accurately recorded it onto his pocket dictation device. Is it like a beep or something? Pocket dictation device. And currently has no memory of its contents. It may also be admitted as a recorded recollection. They do like to test on the exam, you know, try to trick you. There's certain things they try to trick you on, like the marital communications and the testimonial privilege. So, you know, kind of make sure you see the differences between them. They like to trick you on recorded recollection and refreshing a witness's recollection on stand. Like the recorded recollection comes into evidence. The piece of paper to be like, yo, Tommy, this is what you're supposed to say. Oh yeah, I am not a crook. Like that little piece of paper doesn't come into evidence. It's just used to refresh the recollection on the stand. Okay. Sorry, that's my. Oh, you guys don't see my screen. I was just sharing my Florida multiple choice test. I've been working super hard on that. Hard work don't stop, right? All right, what's next? Which of the following? Safwan has been building this MBE practice test, 100 questions, and I've made the Florida multiple choice 100 question. Not gonna lie, these are two of our best works yet. It's just the good keeps coming. All right, which of the following is the strongest constitutional argument for the authority of the president to take action in these circumstances requiring the governor of the state to release the state prisoner? For this question, I'm like, what are they even talking about? So I look at the answers, I peek at the answers. All right, so it's executive powers, non-justiciability. All right, so at least I'm oriented. This is about executive power, non-justiciability. So I'd probably already be telling myself like vet caps. What are the powers of the executive branch? The veto power, the exclusive representatives in foreign affairs, treatise power, commander-in-chief, appointment and removal power, pardon power, and give the Secretary of State speech. And then I'm seeing if any of that applies. Terrorists in a foreign country kidnapped the United States ambassador to that country. Oh shit. Sorry, a new student. Terrorists in a foreign country kidnapped the United States ambassador to that country. They threatened to kill her unless the President of the United States secured the release of an identified person who was a citizen of that country who was held in prison in State A in the United States pursuant to a valid conviction by the state. The old Brittany Griner. The president, sorry, Vic, you weren't supposed to smile at that. The president responded by entering into an agreement with the foreign country, which provided that the country would secure the release of the United States ambassador on a specified date in return for action by the president that would secure the release of the identified person held in the state prison. All right. The president then ordered the governor of the state to release the prisoner in question. The governor refused. No federal statutes are applicable. Which is the strongest constitutional argument for the authority of the prisoner to take action in these circumstances, requiring the government of the state to release the state prisoner? A, the power of the president to conduct the foreign affairs of the United States includes a plenary authority to take whatever action the president deems wise to protect the safety of our diplomatic agents. That seems a little strong to me, honestly. Like whatever action he wants to take, I mean, I don't know. Don't get me started. The power of the president to appoint ambassadors authorizes him to take any action that he may think desirable to protect them from injury, because on appointment, those officials become agents of the president. Honestly, Vic, don't delete A. I might look back at A, because this B looks the same. They're both saying any, whatever action, any action. So maybe that's not the problem here. C, the power of the president to negotiate with foreign nations impliedly authorizes the president to make executive agreements which prevail over state law. Actually, now that I see that answer, maybe A can get eliminated. That answer has a decent ring to it. The duty of the president is to execute faithfully the laws, authorize him to resolve finally any conflicts between state and federal interests, making the determination of such matters wholly non-justiciable. I kind of like C as the best answer here, but y'all can think it through or argue with me. The power of the president to negotiate with foreign nations impliedly authorize the president to make executive agreements with them which prevail over state law. Pretty factual. This to me brings up the conversation of don't pick it yet, because maybe I'm wrong, but it gives me the concept of hierarchy of authority. The Constitution prevails, right? That's the big authority. Treatises are pretty much on par with federal law, whatever was enacted most recently, and then executive agreements, are subordinated under the Constitution, treatises, and federal law, but they are allowed to be made. So like they're allowed to make executive agreements. Is this a time where we're allowed to make executive agreement? What do you think, Vic? You like C? All right, let's run it. I feel confident with Vic on con law. She is like, yeah, in that world. C is correct. Many explicit grants of power have been interpreted to employ the branch of government to do whatever is reasonable to exercise that power. Therefore, the strongest argument is that the power of the president to negotiate with foreign nations impliedly authorizes the president to make executive agreements with those nations. If the action is valid, the supremacy clause would make the agreement prevail over state law. So let's try and dumb this down. I don't mean to say that dumb it down, but let's just try and take a rule of law from this. So the president may validly make executive agreements with foreign nations that prevail over state law. I mean, I told you the hierarchy, right? When Constitution, then treatises and federal law, then executive agreements, and then state law, because all that stuff is still federal, which will preempt state law. So pretty solid. All right, let's try another one. All right, should the witness's notes be omitted? Several defendants, senior executives of corporation, were charged with securities fraud. The government called as a witness another executive of the corporation who had not been charged and who had been given immunity from prosecution to authenticate handwritten notes that she had made after meetings of the corporate's management team at which the alleged fraud was discussed. The witness testified that she prepared the notes on her own initiative to help her remember what happened at the meetings. Hearsay. After this testimony, the government offered the notes into evidence to establish what had happened in the meetings. I mean, I talked to myself during the test. Obviously, you guys know I talk to myself. I talk to myself even when I teach, just to make myself laugh. But during the test, I talk to myself a lot. I give myself high fives. I'm like, oh, easy. This one, I read it and immediately said hearsay. Maybe I'm wrong. Maybe there's an exception that applies, but like it sounded like hearsay to me. Like you made the notes to help remember what had happened, and now we're bringing in the notes to establish what had happened. That seems like hearsay, right? No, because the notes are hearsay without an exception. No, because the witness's immunity agreement with the government makes her notes untrustworthy and thus substantially more prejudicial than probative. Yes, because her business records. Yes, because her past recollections recorded. All right, past recollections recorded would mean that they were accurate when made, and she currently has no memory of them now. There's nothing to say that right here, that their past recollections recorded. There's nothing to say that she doesn't remember them and there's no memory of now. It just says she wrote them to help her remember. Past recollection recorded means you don't remember it now, but it was accurate when made. There's nothing here that says you don't remember it now. Business records, no, because they weren't made in the ordinary course of business. They were made literally because they were trying to come up with team to discuss the alleged fraud, right? And then A,
Fact that they state that she did it on her own initiative is what completely undermines the business records. So like that little fact is really key to
Critical.
knocking that answer out.
right, she did it on her own initiative, and it wasn't like her boss told her to do this. We do this every meeting, you know. She did it on her own initiative. She created some hearsay, and she's trying to bring it in. They're trying to bring it in to prove the truth of the matter asserted. So I like A here. Sorry, yeah. You like A, Vic? Note the notes are hearsay because they're out of court statements offered to prove the truth of the matter asserted. They do not fit in hearsay exception. QC extend explanation. A is correct. The notes are hearsay because they're made out of court and they're being offered to evidence for the truth of the matter asserted, what happened at the meetings. The notes also do not fall within any applicable exception to the hearsay rule. They're not business records under FRE 036 because the witness did not make the notes during the regular course of business. She made them to specifically remember what happened during at the meetings. The notes also do not qualify as a past recollection recorded because the proper foundation has not been laid. First, the witness did not testify that she has insufficient recollection to testify fully and accurately. Like they didn't lay a foundation for past recollection recorded, and the notes were not made during the ordinary course of business. Therefore, ergo, hearsay, right? So, the business records exception to hearsay requires that the notes are made in the ordinary course of business, and a proper foundation must be laid for past recollection recorded which we just talked about here. He currently has no memory of its contents. It was accurate when made. It was made at the scene. All right. Anyone got 100% so far?
Yes.
Nice. That's what I like. That's what I like. My boy Bruno likes to gamble, allegedly. All right. On the basis of these statements, the city council discharged the building inspector. Is the action of the city council constitutional? Let's see. A city ordinance makes the city building inspector responsible for ensuring that all buildings in that city are kept up to the building code standards and requires the inspector to refer for prosecution all known building code violations. All right. Sounds like your job. Another ordinance provides that the city building inspector may be discharged for good cause. Okay. Sounds like valid. The building inspector took a newspaper reporter through a number of rundown buildings in a slum neighborhood. After using various epithets and slurs to describe the occupants of these buildings, the building inspector stated to the reporter, "I did not even try to get these buildings up to code or have their owners prosecuted for code violations because if these buildings are repaired, the people who live in them will just wreck them again." All right, this guy's racist as fuck. The reporter published these statements in a story in a local newspaper. The building inspector admitted he made the statements. On the basis of these statements, the city council discards the building inspector. Is the action of the city council constitutional? I mean, that seems to be like a reading comprehension one. Like we have a dude whose job is to ensure that they're all kept up to standards. And it's his job to refer them for building code violations. And he made me removed for good cause. We got all these elements here. Like this dude is not doing his job. He's not doing his job. And we have good cause to remove him. So can they remove him? I would say yes. Yes, because the statements demonstrate that the building inspector has an attitude toward a certain class of persons that interferes with the proper performance of the obligations of his job. That's the answer. You're allowed to, like, you know, vote for a president and then work for another president. You know, I'm sure, Victoria, you work in DC, like, you know, people work there who don't necessarily support the administration. And it's like, they can't just be fired because of who they voted for, but they can be fired if they, like, you know, make it known that they're contra, like, the objectives of their job. You know what I mean? So yes, because the building inspector is a government employee and a person holding such a position may not make public comments inconsistent with government. That's exactly what I said you can do. You're allowed to be like, yeah, you know, president's probably, you know what I mean? Like, you're allowed to have a voice, but you're not allowed to be like, well, my job is to do this, and I unequivocally will not do that, right? No, because the statements were lawful comments on a matter of public concern. I mean, they were, but that's not why it was constitutional to discharge him. And no, because the statements were published in a newspaper that's protected by the 14th Amendment. So,
Andrew, can I just ask something? The comments inconsistent with current government policy, didn't he say, I mean, isn't the policy to prosecute people who are in violation, but he says he's not going to do that?
yeah, it says,
I'm
I did not even
having trouble
try to get them
between-
up to code or have them prosecuted. But his job literally said, you have to get them up to code and require that you refer for prosecution. And he said, I don't get them up to code or try to have them prosecuted. It's like me saying, all right, Susie, I'm hiring you to be a tutor. I need you to teach math and science. And she's like, yeah, I don't teach these kids math or science. You know, I go on TikTok all day. It's like, you're not doing anything you're supposed to do. You're out of here, chief.
Right, so wouldn't that be I'm just trying to think this through. Would that be not be inconsistent with the policy?
It would be, but that's not the correct reasoning. You're allowed,
Okay.
like, B is a true statement of law that he said something inconsistent with the policy, but it's not the reason why he's being discharged. The reason that he's being discharged is because he's saying statements that make it unequivocal that he's not going to complete his job. Like the other question is about the dude who works for the mayor. And he said something like, yeah, I voted for the other dude, you know, he's going to reduce my student loans, you know, fair enough, right? So now the mayor
Oh, I see.
right? That's not fair. You can't discharge him just because you don't agree with everything he says, but you can discharge him if he makes it known that he will not perform his job as required. So yeah, let's run it.
Okay.
Like, yeah, be careful, Vic. A is careful. Public employees have a First Amendment right to speak on a matter of public concern. B is incorrect. Government employees have First Amendment right to comment publicly on matters of public concern, right? That's the same thing. You're allowed to talk about matters of public concern and may not be discharged for that speech unless the employee's actions interfere with the function of government. So let's say that, you know, a government employee has First Amendment rights of freedom of speech. They can speak on matters of public concern. But they can be held responsible, discharged, for example, if they communicate an unwillingness to perform their job / responsibilities. Responsibilities? Sorry. Perfect. Okay. New question, new poll. Doing pretty good, right? I mean, if you don't understand, like, this is all y'all should be doing, you know what I mean? Like, to an extent, not all y'all should be doing, but a lot of your day should be doing this. If I was, you know, coaching a basketball team, I think you guys should be playing a lot of basketball, right? Like, it's the thing that's going to work. You got to do things and master it and just get better. And I talked about before the class about how I'm really keen on Eastern education and why Western education is on the heavy downfall, like steep decline. It's because our lack of discipline and our desire to do things the easy way. I mean, I've been talking about the advantages of AI and ChatGPT. Yeah, if you don't know something, ask ChatGPT. Hey, bro, can you explain this, dear ChatGPT? Dear ChatGPT, can you please explain this to me? I don't understand it. Can you make it easier? Can you include a pink pony in the example? Like, you're allowed to do that stuff. It's there for you. But at the same time, like, that also makes people lazier and just makes people not learn. Like, just because something has been printed out for you and you have it in a, you know, people will like print out all these materials and be like, oh yeah, I look, I studied all this. It's like, I would rather you just pick the same flimsy little packet that every student has and just master everything in that packet than for you to go out and buy all these bells and whistles. You know, it's kind of like, why are kids so good at baseball in Cuba? They play with sticks and rocks, right? And then the kids in America who have all the nicest gear, they're not making it that far. It's obvious why it's the case. It's not about the fancy stuff. It's not about doing magical things. It's about having discipline, having grit, working hard, and just hammering away at the things that work. And you know, in Cuba, they probably play a lot of baseball. Like all day long, they're playing baseball, right? If you want to do well on the MBE, you should probably do a lot of MBE questions, right? All right, let's look at the witness's testimony. So let me add this. Oh no, the poll's already been up. All right, cool. So the witness testimony is blank. A defendant charged with possession of heroin. The prosecution's witness, an experienced dog trainer, testified that he was in the airport with a dog trained to detect heroin. As the defendant approached, the dog immediately became alert and pawed and barked frantically at the defendant's briefcase. The defendant managed to run outside and throw his briefcase into the river, from which it could not be recovered. After the witness experience was established, he is asked to testify as an expert that the dog's reaction told him that the defendant's briefcase contained heroin. Simple, right? Is a dog barking hearsay? Can it ever be hearsay? Absolutely not. Can a machine recording be hearsay? No. Why not? What is hearsay?
Hearsay only applies to out-of-court statements by people.
Out-of-court statements. We don't constitute this as a statement. It's a dog barking. It's a machine recording, not hearsay. So, A, admissible as evidence of defendant's guilt. B is not true. It's not hearsay, right? Like, this is just not a true answer. Who cares if you can or cannot rely on it? C, not hearsay. D, unreliability of the reactions of an animal. Trust me, it was heroin. Animals are fucking good at smelling what they're supposed to smell. Like, I think, again, the weight of the evidence is for the jury, but like, these animals are pretty good. Like, animals have superpowers that humans, even with all our amazing technology, can't be as accurate as. Like, dogs can sniff cancer cells before, whatever, that's not the point of this. The answer is A. Can we go to A, Vicky? You know I love dogs. All dogs go to heaven. So A is correct. The dog's behavior of drawing attention to the defendant's briefcase was not hearsay and is admissible as evidence of the defendant's guilt. Hearsay is an out-of-court statement that is being offered for the truth of the matter asserted. A statement is either an oral or written assertion or nonverbal conduct of a person, as Heather was saying, is intended by the person as an assertion. If it's intended as a person by an assertion, because a dog is not a person, its reaction to the defendant's briefcase do not amount to that statement. I'm sure when we do our master cram guide, it was probably on here like 7 times. Like, dogs barking are not statements that can be considered hearsay. Neither. You know what's one of the funniest things? Like, this has been a funny administration for me. I've said some funny stuff. I make myself laugh. But Eric, one day we were talking about season or season, or we were talking about like this or that. And I was like, how do you spell this word? And then I spelled it wrong in the chat. Like, that's not even how you spell neither. Not only did I not know how to spell it, it's E-I. I spelled it N-I-E. I was like showing off my rockiness. Okay, so neither is machine statements, or not machine statements. Neither is machine readings like a speedometer. No, a speed sign. Speed sign. I don't know what those things called. Speed tracking thing. Speed tracking device. Let's just call it device. All right.
You mean radar, like a radar detector?
Yeah, like a radar detector. Exactly what I'm talking about. Like a radar detector. All right, let's do another one. What did ChatGPT say about the game tonight? Eagles are going to win. So should the court uphold the agency's decision? Congress recently enacted a statute creating a program that made federal loans available to family farmers who had been unable to obtain loans from private lenders. Congress apportioned a fixed sum of money to fund loans made pursuant to the program and gave a designated federal agency discretion to decide which applicants will receive the loans. Fair enough, right? They have this ability to be like, hey, whoever gets the cut is from the list of qualified candidates. Like, you know, it is a fair, regular procedure. The agency is going to have discretion. 2 weeks after the program was established, a family farmer applied to the agency for a loan. Agency officials promptly reviewed her application and summarily denied it. The farmer has sued the agency in federal district court, claiming only that the denial of her application with the opportunity for a hearing violated the due process clause of the Fifth Amendment. The farmer claims that she could never approve such a hearing that without the federal loan, it would be necessary for her to sell her farm. The applicant claims that she could have proved at such a hearing that without the federal funds, it wouldn't be necessary for her to sell her farm. Boo fucking who, right? Like, just because you're going out of business doesn't mean the government has to bail you out. At least we'd like to think that. No, because the due process requires federal agency to provide a hearing before making any factual determination that adversely affects an identified individual on the basis of his or her particular circumstances. No, because the denial of a loan may deprive the farmer of an established liberty interest to pursue her chosen occupation. Yes, because the applicable statute gives the farmer no legitimate claim of entitlement to receive a loan. Yes, because the spending clause of Article 1, Section 8 gives Congress plenary power to control the distribution of appropriated funds in any manner it wishes. D could be a good answer, but that any manner it wishes, we don't really like. I'm seeing the votes roll in. I feel like every single person in the class is getting this question right. Maybe it's because y'all seen it before, or maybe because it's pretty obvious. This person didn't deserve a hearing. They didn't make the requirement. That would be like Andrew applied to, what school would be tough? Andrew applied to UC Berkeley. True fucking story, when I was in high school, and did not get accepted. Even though I did a program at UC Berkeley over the summer to beef up my application, they was just hating on the kid. So Andrew did not get accepted into UC Berkeley. Andrew wants a hearing for, why he got denied. Like, no, bro, you didn't get accepted because your shit wasn't good enough. Like, they don't have to give you a hearing. Even though they're a state school, they're allowed to deny people based on their qualifications. You don't just automatically get a hearing. I don't know why I wanted to go to Berkeley. I just wanted to go to California when I was a kid. It seemed like the cool place. All right. Oh yeah, C as in Caterpillar. C as in Cal Berkeley. C is correct. The court should uphold the agency's decision because the due process clause did not require the government to provide the farmer with an opportunity for administrative hearing on a loan application. The farmer had no legitimate claim of entitlement to a loan because the statute gave the agency discretion to decide which applicants will receive the loans. The agency's denial of the application, therefore, did not deprive her of property or liberty interest protected by the due process. Right. So due process obligates agencies to provide an individual the opportunity for hearing only when the agency makes an adjudicatory decision that deprives the individual of a property or liberty interest that is protected. The agency's decision was not a property or liberty interest, right? So we can just say a government program that gives discretion for awarding loans based on strength of applicants is valid, and there's no right to notice and hearing for those denied the loan. And you see, they try to like pull at your heartstrings a little bit. They're like, oh, well, this farm's going to go out of business. It's like, go to California. And there's a lot of people out of business on the streets there. It's just the way the world works. All right, can we do another question? I'm going to go out of business if I don't work my ass off. That's how I feel. All right, testimony by the investigator is blank. A plaintiff sued a defendant for personal injuries suffered in a train automobile collision. The plaintiff called an eyewitness who testified that the train was going 20 miles per hour. The defendant then offers a testimony of an experienced police accident investigator that based on his training and experience and on his examination of the physical evidence, it is his opinion that the train was going between 5 and 10 miles per hour. Are we going to allow this to come in? Improper because there cannot be both lay and expert opinion on the same issue. I don't like that. Improper because the investigator is unable to establish the speed with a sufficient degree of scientific certainty. Proper because a police accident investigator has sufficient expertise to express an opinion on speed, or proper because a plaintiff first introduced opinion evidence as to speed. All right, so we're trying to figure out how fast this train was going. First, we got an investigator who's based on training, experience, and examination, states his opinion that was going 5 to 10 miles per hour. The eyewitness said it was going 20. How fast was the train going? This is a GRE question. right? One train leaves the station. I like teaching the GRE. I like teaching math. Math, you can't argue, man. These questions y'all arguing for. I'm like, no, the answer's 7. Like, put in your calculator. Put in your calculator and smoke it. It's 7. So here, what's going on here? How much is it? Again, it's law. There's no black and white answer. We don't know how fast the train was going, but wouldn't it be valuable to, the eyewitness has personal knowledge. He says, bro, I think that thing was going 20. And then the expert who has been at this point, if he's already on the stand, he's been qualified. Can he give expert opinion? Yeah, it's based on, I don't see a reason why not. I'm rocking with C, right? You don't need to introduce opinion to give expert opinion. First, introduce opinion evidence as to speed. No, you don't need to like an expert witness is allowed to give expert opinion regardless if it's in rebuttal or if it's in presentation. Let's go with C. That's the class picked. All right. C is correct. If scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or determine a fact at issue, a witness qualified as an expert by knowledge, skill, expertise, training, or education may testify thereto in the form of an opinion. The police accident investigator's opinion was based on sufficient facts, was a product of reliable principles and methods, and the investigators applied the principles and methods reliably to the facts of the case. The testimony of the investigator, because he has sufficient expertise to express an opinion, is admissible. All right. I mean, this one's kind of like a simple takeaway, I guess, but I would just say a validly, let's say, qualified expert witness may make opinions based on his or her specialized training and experience and expertise. My family, my parents, my dad and my brother, my mom, they do real estate appraising. And I always tell them, I'm like, y'all should be expert witnesses. Just get paid to go in front of the court and be like, yeah, I think the house was worth like $1 million, Just think that's like a good idea for them, but they're doing fine. We're all doing fine. Life is good. Our team's in the Super Bowl. Okay, let's do another one, Vic. All right. In action against the railroad, the plaintiff should recover what? Does anyone mind reading this question to the class?
I can
Sean.
read it.
Oh, that'd be perfect. Yeah, beautiful. Yeah. Let's see it.
Okay. So in his action against the railroad, the plaintiff should recover what? So a plaintiff suffered a severe loss when his manufacturing plants, located in a shallow ravine, was flooded during a sustained rainfall. The flooding occurred because the city had failed to maintain its storm drain, which was located on city land above the plaintiff's premises, and because the railroad had failed to maintain its storm drain, which was located on railroad land below the plaintiff's premises. The flooding would not have occurred if either one of the two storm drains had been maintained properly. The plaintiff sued the railroad to recover compensation for his loss. The evidence in the case established that the failures of the two drains were caused by the respective negligence of the city and the railroad. There was no special rule insulating the city from liability. So in his action against the railroad, the plaintiff should recover A, nothing, because he should have joined the city, without whose negligence he would have suffered no loss. B, nothing, because he did not introduce evidence that enables the court reasonably to apportion responsibility between the city and the railroad. C, 1/2 of his loss, in the absence of evidence that enables the court to allocate responsibility fairly between the city and the railroad. Or D, all of his loss, because but for the railroad's negligence, none of the flooding would have occurred.
Amazing. All right, everyone take a minute to think about. Let's let the class argue this one out. All right. Anyone feel confident about this one?
I feel pretty confident about it. Famous last words.
Yeah. All right. Well, I'll give you the class's results. Do you agree with the class is saying D?
Yeah.
All right.
Yeah, I do. It's because you're not going to punish the plaintiff for, you know, the fact that like either one of the defendants is going to be liable, and I'm pretty sure the default rule is joint and several liability on the MBE, so it doesn't speak at all to what the standard of apportioning damages is. So in that case, you would assume joint and several liability. He can go after either one of the other two plaintiffs, and then they can seek contribution from the other. Or, sorry, against the defendants, and the defendant that he's successful against can go against the other defendant for contribution.
Right. So D is correct. The but-for test is satisfied where several acts combined to cause the injury, but none of the acts standing alone would have been sufficient. But for any individual acts, the injury would not have occurred. Here, although the plaintiff's damage suffered for the negligence of two independent entities, neither of alone which have been sufficient to flood the plaintiff's manufacturing plant, the combined negligence satisfies the but-for test. Therefore, the plaintiff may recover all of his losses. A is incorrect. The city's absence from the plaintiff's action will not affect the railroad liability as a jointly liable concurrent tortfeasor for the entire amount of plaintiff's award damages. B is incorrect. The plaintiff is not required to introduce evidence to enable the court to apportion responsibility. The railroad is liable for the entire amount of damages as a jointly liable concurrent tortfeasor, and there are several options to recoup damages from the city. That's exactly what it's saying. So like, if a party is the but-for cause of injury, even if the injury wasn't totally a result of their negligence, and there were contributing tortfeasors, the plaintiff can recover the full amount from the defendant. All right, sweet. Amazing job, Gabby. I did not realize how hungry I was. I just crushed that acai bowl. All right, let's do the next one. I had a student today before this from 8:30 to 10:30. And I had a student last night until like midnight. I think they're both in the room, so they can attest, they can corroborate my statements. All right, a man has committed what? A man asked his friends if he would loan him $500, promising to repay him the amount in 2 weeks. Oh, let me put up a new poll. Sorry. Are you guys gonna miss these classes when it's done? You're gonna miss spending 6 days a week with me, 8 classes a week with me? I'm gonna miss it so much when I'm chilling on the island, sipping mimosas. I'm gonna be like, damn, I missed this class. All right, a man asked his friend if he would loan him $500, promising to repay the amount within 2 weeks. The friend loaned him the $500. The next day, the man took the money to the racetrack and lost all of it betting on racehorses. This sounds like so many of my friends I grew up with. He then left town for 6 months. He has not repaid his friend. The man has committed both larceny by trick and obtaining money by false pretenses, although he can only be convicted on one offense. It's kind of an interesting concept. They're trying to confuse you with that, right? Like they're trying to give you merger, like, oh, larceny merges into robbery, but these are different claims. These are different crimes. So you can be convicted of both of them. I mean, if you did both of them. Larceny by trick only, obtaining money by false pretenses only, or neither larceny by trick nor obtaining money by false pretenses. So he took the money. When he took it, he was going to repay him. Took the money to the racetrack and lost it all. Then he left town.
I like D.
Yeah, I like D too. Tell me why you like D, and I think I agree.
Because it goes to his intent, and the intent for larceny is the intent to deprive somebody of their property. The intent of false pretenses is the intent to defraud. And I don't think that he had either of those requisite intents here. He intended to borrow the money, pay it back, he lost it, and then that was the end of that. So
well, let me ask you, is there a crime he could be convicted of?
Is
the man innocent? He doesn't seem innocent to me.
No, I mean, he's basically absconded with the money, or he doesn't have the money.
Can anyone clarify this? He's guilty of something here, but what's he guilty of? He's not guilty of any of the things here. I think you said something that I don't exactly agree with. You said he can't be guilty of larceny.
Maybe embezzlement.
Maybe embezzlement or maybe larceny, right? Like when he took it, at some point he decided to take it, but it's not larceny by trick and it's not by false pretenses. Like at some point down
I
the
don't
line,
think it could be larceny either. It's the intent to permanently deprive. That's larceny.
well,
The decision to flee might be tied to, his ability to deprive. So at that point, it becomes larceny.
Oh, right, because but isn't the intent to permanently deprive at the time it's taken?
not necessarily. If you take something and hey, I'm going to give it back, and then at some point, you're like, you know what? Nah, I'm not going to give it back. Then it becomes larceny at that point. But I think what this one was getting at is by trick or by false pretenses. There was no deception here. But at some point, yeah, bro, you stole the money and absconded with it. I like that word. You absconded with the money. Maybe actually embezzlement could be. I like that. There is an embezzlement. You were, but I don't know. You were supposed to give it back, and at some point, you decided you weren't going to give it back. If I was the prosecutor here, which Lord, I would never be. I don't like to put people in jail. I just don't even like to defend criminals either. I have no interest in any of that. But if I was the prosecutor, I would stick him with larceny. I'd be like, yeah, but when you left town, that's when you stole it. But here they're asking about larceny by trick and by false pretenses. He never tricked him, nor did he ever give him false pretenses. He told him truthful things. He just later absconded with it. So I agree with D. You agree with D, Vic? I just don't think there's any fraudulence here yet. There's no evidence that the man, when he obtained the money from his friend, had intent to permanently deprive a friend of it, and there's no evidence that the man made any misrepresentations or fraudulent statements that induced his friend. A simple promise to pay, even if the debt is not paid, is insufficient evidence to prove the intent to permanently deprive. In addition, a simple promise to pay is insufficient to be considered a false or misleading statement. So, yeah, B and C are incorrect. The man did not commit larceny by trick because he did not obtain possession of the money through false statements of past or existing fact with the intent to defraud. And C is incorrect. The man did not obtain money by false pretenses because he did not obtain title of the money through false statements of past or existing fact with the intent to defraud. So you see, they're the exact same thing. It's just larceny by trick is possession. False pretenses is title. So let's kind of flesh this one out a little bit. So the difference between larceny by trick and false pretenses is larceny by trick. The perpetrator obtains possession, whereas false pretenses, the perpetrator obtains title. Asking a friend for money, say with the intent to pay him back, but later losing the money on the parlay is not false pretenses or larceny by trick because there was no concurrent intent to deprive and false assertions or statements. Right? Like again, Heather, it doesn't really matter because of what larceny wasn't a answer choice here. But if they put larceny as an answer choice, I would have a hard time picking against it because I'd be like, well, yeah, at some point, like you kind of decided that you were going to permanently deprive them, and it doesn't have to be like pinpoint.
I have to disagree with you on
That's
that.
fine. That's fine. You can disagree. You can disagree, but let's not confuse the class. I'm probably right. At worst, it's a civil case for conversion. Yeah, I agree with Eric. Okay. All right. Let's do another one. Okay. All right. So which of the following steps should the prosecutor take to get the woman to answer the question? A woman was subpoenaed to appear before a grand jury. When she arrived, she was taken into the grand jury room to be questioned. She answered preliminary questions about her name and address. She was then asked where she had been at a certain time on a specified night when a murder had occurred. Before answering the question, the woman said that she wanted to consult her attorney, who was waiting outside the grand jury room and was allowed to do so. When she returned to the grand jury room, she stated that she refused to answer the questions because the answer might incriminate her. The prosecutor believes the woman's nephew committed the murder. The nephew said that he was with the woman at the time of the murder, and the prosecutor believes that this alibi is false. The prosecutor does not believe that the woman is guilty of the murder, either as a principal or as an accomplice, although he does believe that the woman may be guilty of other crimes. The prosecutor wants to compel the woman to answer the question by whatever means will result in the least harm to the prosecution's case. All right, this is very procedural. Which of the following steps should a prosecutor take to get the woman to answer the question? All right, this one was a little bit tough. And as I was reading, I'm like, nah, I do think it's large. No, I'm just kidding. But this one's a little bit tough. And there was some key pieces to it. Like, what's going on here? They're trying to say something and she's refusing to answer the question because it might incriminate her. What does that implicate? Refusing to answer a question.
Fifth
Fifth
Amendment.
Amendment. So you're pleading the fifth. Okay. But now they're saying, look, we need you to compel that answer. So that's what's going on here, is that they're trying to compel even though there's a privilege. So the only way they're going to get them to compel this is if they can really protect her and be like, yeah, we're going to make you say it, but don't worry, it's not going to come back to haunt you. So what are some ways we could do that? Request the grand jury to order the woman to answer the question. Ask the woman's attorney to explain to the woman that rules of evidence do not apply in grand jury proceedings and advise her that she can refuse to testify. Trap answer. The rules of evidence do not apply in a grand jury, right? But the rules of privilege do. So you still have attorney-client privilege. You still have your right against self-incrimination. These are some of the rules you have. It's just like the hearsay rules and like, the major rules of evidence that do not apply. Prepare the documents necessary to grant the woman immunity from any future use against her of her grand jury testimony or any evidence derived from it. Prepare the documents necessary to grant the woman immunity from any future prosecution for any crime she might disclose in the course of her testimony. So, definitely going to be immunity, right? Definitely need to grant her immunity. Do we want her to grant immunity for future use against her or her grand jury testimony or evidence derived from it, or immunity from any future prosecution for any crime she might disclose in the course of her testimony?
I think D is a better answer for trying to induce her to testify. I mean, like C, yeah, you could say that, we're not going to get any evidence out of this, but I feel like D is like any of the evidence that, or any crime that we elicit from your testimony, like that, the concern that she has is self-incrimination, right?
Mm-hmm.
So that's why I thought it was D instead of C.
I think the critical part was the second to last sentence where he wants the least harm to the prosecution's case. And that's why I lean towards C, because D might harm prosecution's case on like a lower matter, not relevant to her testimony. So that's why I picked C.
Anyone else? I mean, I'm here. Tamara, what are you thinking? D versus C? What's your point?
Andrew, I wrote it down because I'm kind of losing my voice again. But I do think the D argument is very strong, but that because it kind of puts universal protection shield for any future prosecution for any crimes, it's very strong. So I'm choosing C, that still uses any future use, but the word use against her of her grand jury testimony is more specific for the type of the crime that they are trying to take from her in this situation. So I'm going with C.
So C and D are talking about derivative use versus transactional use. And I think I kind of like what Sean was saying, that C would be less damaging to the prosecution's case. I think I like C. I like that the class went with C. I appreciate you, Eric. I'm gonna rock with the class with C, but let's read the explanation anyway. What do you think, Vic?
Andrew, I think the reason why D is wrong is because you can still get evidence from somewhere else, and you can still use that because it's outside of the evidence of the grand jury testimony. So if you pick D, that would prevent use of other evidence that the prosecution may obtain.
I didn't have the confidence to say this, but it is what I thought it was. It's a difference between derivative use and transactional use immunity, right? use and derivative use is more narrow. Transactional is more broad, but like he was saying, there could be other crimes that are implicated, and like Sean was saying, this is more narrow. Let's read the explanation. This is a really tough concept. Let's see if we can glean anything from it. C is correct. A witness cannot be compelled to provide potentially incriminating testimony unless the witness is granted at least use and derivative use immunity. As stated above, right? So let me take that down. So a person, holy smokes, a person can be compelled to incriminate themselves despite the Fifth Amendment protections if they receive use and derivative immunity. All right, let's just put that on the paper because it sounds nice, but let's read what it really means. So I stated above, the woman cannot be compelled to provide potentially incriminating testimony unless she's granted use and derivative use immunity. D is incorrect. Well, C, B, like I said, while most rules of evidence do not apply before grand juries, the witness cannot be compelled to provide potentially incriminating testimony unless the witness granted use and derivative immunity use. Witness cannot be compelled to provide potentially incriminating testimony unless the witness is granted at least use and derivative use immunity, but the witness need not be granted transactional immunity. So let's add that to the Graham guide. Transactional immunity does not need to be provided. All right, let's learn a little bit more about derivative use and transactional use. So a witness may be compelled to answer questions if granted adequate immunity from prosecution. The U.S. Supreme Court has held that granting use and derivative use is sufficient to extinguish this privilege. Castigar versus the U.S. Use and derivative use immunity guarantees that the testimony obtained and evidence located by means of testimony will not be used against the witness. The other type of use that may be given is transactional, which guarantees immunity from prosecution for any crimes related to the testimony of the witness. So a key takeaway from this is just the difference between use and derivative use immunity versus transactional immunity. And right, for those of you who, using the newfound technologies of the time, that'd be a great thing for you to ask ChatGPT to really give you examples or whatever it may be. But for our sakes and purposes, we're just going to take the main things. So use and derivative use is protection from the crime. Transactional use is protection from all crimes. So if you go back to the question real quick, Vic, just want to see what C and D, what the real difference was. C said immunity from use against her or any evidence derived from it. And then D said future prosecution for any crime. So yeah, so for any crime is protection from prosecution.
So to kind of dumb this down, C is basically saying we won't use any of the evidence elicited from you in this grand jury hearing for a potential crime in the future, whereas D is saying any crime tied to the evidence at all, we're not going to prosecute you for. So it's just, yeah, I think that's kind of like the gist of it, right?
Yeah, that's fair enough. Good stuff. All right, let's do like 2 more questions and then we'll call it a Super Bowl Sunday. All right, Vic, you want to do a couple more questions for the gang? Of course. Can't find the poll. All right. Well, you brave soldiers might have to put your answers in the chat for this one. I don't know. I can't find the poll. All right. If the man sues for breach of contract, can we skip this one, Vic? I don't want to do this one. This one annoys me right now. Okay, perfect. The court should admit evidence of what? A defendant is on trial for arson. In its case in chief, the prosecution offers evidence that the defendant had secretly obtained duplicate insurance from 2 companies on the property that burned, and the defendant has threatened to kill his ex-wife if she testified for the prosecution. The court should admit evidence of the defendant's obtaining duplicate insurance only, the defendant threatening to kill his ex-wife only, both the defendants obtaining duplicate insurance and threatening to kill his ex-wife, and neither the defendants obtaining duplicate insurance nor threatening his ex-wife. Trying to find this poll. All right, I appreciate you guys picking the answer in the chat. I don't know why I lost my poll, but what do y'all think? It seems everyone in the chat is picking C, both. Does anyone explain why they think it's C?
I think it's both, because when I looked at it, obviously threatening to kill his ex-wife if she testified for prosecution, that's like intimidating someone to like have it your way. So it's like it's an unfair trial. And I think the same thing with like secretly obtaining duplicate insurance. Like, why does he need a duplicate insurance from 2 companies?
Yeah, right? Motive.
Yeah,
Everyone,
definitely with motive.
anyone disagree with C? All right, so
I kind of do, but I'm not brave enough. Oh, yeah.
all right, both the defendants obtaining a duplicate insurance and the threat to kill his ex-wife if she testifies are relevant and admissible under FRE 404B for purposes other than bad character show conformity therewith. The duplicate insurance is for motive, and the threat to kill ex-wife is relevant for plan, knowledge, and consciousness of guilt. Okay, that's a good one. Consciousness of guilt. I don't always think about that one because mimic, I think of C as like common scheme or clan, but it could also stand for consciousness of guilt. So let's just say if a man is accused of burning, of arson, what exactly happened here? Can you go to the question real quick? He's on trial for arson, and there's evidence that he obtained duplicate insurance, and they threatened to kill his ex-wife. Okay. The man is accused of arson, both evidence of obtaining duplicate insurance for motive and threatening to kill ex-wife for testifying. It's called consciousness of guilt are both admissible as mimic exceptions, right? To the general rule that specific acts are inadmissible. Show propensity for conformity. Right, mimic ones could be pretty tough. And yeah, that one's not easy one. I'm sure there's arguments both ways, but pretty solid. All right, Vic, you think we can do one more question?
Yeah, Andrew, could we do a contracts question? Because I think it's the only subject we haven't touched.
Yeah, we can do any question you want.
It's past till you go to contracts.
All right.
Sorry.
Why are they
Oh, it's okay. Let's try one. I don't know why it's.
What's the word for when you like
Oh, here.
keep things to yourself from people? B as in basketball. Let's do a different one. Wait, no, don't pick me, don't pick me. I'm just kidding. Never mind. Okay, let's do this one. Do pick me. I almost killed us. Okay. A buyer and seller entered a contract for the sale of a 10,000 novelty bracelets. I didn't know it was risk of loss. I thought they were asking when to identify to the contract. Ooh, that was almost my mistake. Good hesitation. Way to stand in the flames with us, Vic. All right. A buyer and seller entered into a contract for the sale of 10,000 novelty bracelets. The seller had the bracelets in stock. The contract specified that the seller would ship the bracelets by a third-party carrier. However, the contract did not specify either who was to pay the cost of carriage or the place of tender for the bracelets. On the above facts, when would the risk of loss of the bracelets pass to the buyer? So we have a shipment contract here, and there's no discussion of when the risk of loss passes. When the contract was made, when the bracelets were identified to the contract by the seller, assuming the goods conform to the contract. I jumped to that answer because I thought they were going to say when were when were they identified, but not the question. When the bracelets were delivered to a carrier and a proper contract for the carriage was made, delivered to a common carrier, or when the bracelets were unloaded on the buyer's premises by the carrier. So the answer is C or D. Is this a free on board destination contract, or is this a shipment contract where the risk of loss passes upon delivery to a common carrier? The answer here is going to be it's a shipment contract. It would have to say FOB and then name the destination city, free on board, and then say Miami for the risk of loss to pass when it gets to Miami. Otherwise, right when the dude in Seattle puts it on the common carrier, the risk of loss passes. So I agree with what the class is saying here, that the answer is actually C. Wow, amazing work, Victoria. You saved us from the red light of doom. Yeah, good job. All right, but let's do uno más. One more question. Try any question you want, any subject, but just know that the risk of loss passes to buyer when the goods are delivered to a common carrier under a shipment contract. All right. Cool. All right. All right, last question. If the bank becomes aware of the contract between the seller and buyer and the buyer refuses to pay anything to the bank, is the bank likely to succeed in action against the buyer for $5,000? Final question of the day. Honestly, at this point, the Eagles, if this was comparable to the Super Bowl, it's like we're up 50-0. We put in all the backups. Let's see if we can just punch one more in to give someone that glorious moment of scoring a touchdown with their family there, like Will Shipley or someone. All right. So if the bank becomes aware of this contract between the seller and the buyer refuses to pay anything to the bank, is the bank likely to succeed in action against the buyer for $5,000? A seller borrowed $5,000 from the bank. Soon thereafter, the seller filed for bankruptcy, having paid nothing on his debt to the bank. 5 years after the debt had been discharged in bankruptcy, the seller contracted to sell certain goods to a buyer for $5,000. The contract provided that the buyer would pay $5,000 to the bank. The only debt that the seller ever owed the bank is the $5,000 that was discharged in bankruptcy. The seller delivered the goods to the buyer who accepted them. If the bank becomes aware of the contract between the seller and the buyer refuses to pay anything to the bank, is the bank likely to succeed in action against the buyer for $5,000? No, because the buyer's promise to pay the bank was not supported by consideration. No, because the seller's debt was discharged in bankruptcy. Yes, because the bank was an intended beneficiary of the contract between the buyer and the seller. Or yes, because no consideration is required to support a promise to pay a debt that has been discharged in bankruptcy. All right, well, what's going on here? Who is the bank? The contract provided that the buyer would pay $5,000 to the bank. So who has the bank become?
An intended beneficiary of the contract.
Yes, you kind of skipped a step to get there. I agree with you, but how do you know they're an intended beneficiary? Before we even call them intended beneficiary, what would we call them?
A third party?
Yeah, who's been...
They're identified in the contract.
Well, when you... Who said it?
Assigned.
It's either an assignment or a delegation right here. Like there's rights to the contract that have now either been assigned or delegated. Is it an assignment or a delegation?
Assignment.
How'd you know?
Because the rights are being assigned, not a duty would be a delegation.
Beautiful. The rights would be assigned, a duty would be delegated. Here it's the right to receive money. So I agree with everything you said, Heather. I just wanted to tease it out for the class. They are an intended beneficiary. Why? Because they're an assignee. And the rule of law is an assignee to a contract is also an intended beneficiary. So I agree with C here with the class that as an assignee to the contract, they're also going to be an intended beneficiary. You like C, Vicky? Vicky G?
And to take it a step further, they can assert the same the rights as an intended beneficiary.
All right. And before we go to this, let me just add this last thing. Don't change the screen, Vicky, because I want to get a little recording of our perfect score. Eagles green. It's all good vibes for something I'm trying to manifest this evening. Okay, so the rule of law is an assignee of a contract is an intended beneficiary who can assert rights under the contract. And just to put a little cherry on top, I like what Heather was teaching the class. The difference between an assignment and a delegation is that an assignment is of rights, the right to get paid, for example, and a delegation is of duties, the obligation to perform, for example. All right, amazing. All right, Vicky, can you show the class how we did today? Did we get any wrong?
I wasn't able to answer the last question because like the poll went off.
Oh, no worries. But you got them all right, Gabby, beside the one with no poll?
Just one
Just-
incorrect.
Amazing, right, Gabby? I'm confident in you because of what I professed at the beginning of class, that if you could just master these questions, even if it's only because of repetition. And to be fair, Gabby and I have been working on these questions for a long time together. She's seen a lot of them before. That's still likely to result in a passing score because it's a fireproof method. It's a bulletproof method that if you can just get all the questions right because you've done them before, you're actually not getting them right only because you've done them before. You're getting them right because you understand them a lot. Like there's some questions I immediately looked at, I was like, oh, Vicky, the answer is B. But I was wrong. I had to actually read the question and then think about it and get the right answer. So
you made me almost second guess my first answer for the first question. When you said subject matter jurisdiction, I looked at it and I was like, wait, I put the answer for personal jurisdiction. Then you like stopped and then you were like, oh no, it's D. I was like, okay, I thought I was going crazy.
100%. And because look, I'm not as much as people want to belittle what I do, I'm not just a machine. Like I have to read every question and just at least make sure it is the question I think it is. But at the same time, there are thoughts going on every single time. No one is at the point, not even me, who's been doing this longer than anyone, that can just memorize all the questions because they've seen them. I refuse to believe that. I've also proven time and time again, I don't really believe in photographic memories. If people had photographic memories, then they would do the test one time and then be able to get it again right the next time. So like what I really believe in is learning through repetition. I can't believe in anything more than that. So I hope that you guys all really enjoyed today's session. 18 questions, 18 correct answers. You could spend the rest of the day until kickoff doing lots more questions and continuing to reproduce this activity that we did today as a class. Like I said, next week, we're going to do one, if not two proctored exams, and then we'll do a Sunday workshop. And then the last week, I'll update you if we do any classes for the remaining days. But I really appreciate everyone. And it goes without saying, go Birds, but have an amazing rest of your day. Thank you so much.